I'm attorney Allan Friedman. I'm here today to talk to you about risk of injury charges in context of a domestic violence allegation. Now, domestic violence cases can sometimes be rather serious. Sometimes very serious injuries occur, and sometimes children are hurt in the process. But a lot of times, my clients are simply having a verbal, heated argument, and their children happen to be in the house. And sometimes the police will charge the adults with the crime of risk of injury to a minor, which is a very serious offense here in Connecticut. It's a Class C felony, and you can face up to 10 years in jail. The statute is a very broad statute. It's called a catch-all statute, right? And the basic definition of the statute is a willful or unlawful act that places the life or limb or health or morals, which is really what we're talking about here, the morals of a child under the age of 16 in some danger, right? So you're placing the morals of a child in danger by having an argument in your house about the bills. And you're having a breach of the peace, which is a misdemeanor, but now because your children were listening to it, I mean, yes, I'll agree, that's not the best idea to have an argument in your house where your children are listening. But to escalate that to a Class C felony is just, in my estimation, over the top. Look, if one of the parents is holding an infant in their arms, right, which happens all the time, and then the other parent is screaming and yelling and slaps the parent or tries to grab the child out of their arms or something like that, I can see the charge of risk of injury to a minor because there is some possibility of harm occurring. And it's pretty dangerous what's happening. But these situations where the threat or the risk to the morals of the child is so hypothetical and speculative and you add this very serious felony, the Class C felony by the police, is just overreaching. Now, a lot of police departments won't do this unless there's something more tangible that's happening with the child, but you're kind of like playing Russian roulette as to which police officer is going to do it, which police department. We see it happen quite often where this charge is kind of tacked on. And the reason why it's a problem for domestic violence cases for two reasons. Reason number one is a lot of first-time offenders in a domestic violence case might be using the family violence education program. Now, I'll put a link for the family violence education program in the description of the video if you're curious about reading about that. And that's a diversionary program which is not applicable to the charge of risk of injury to a minor because it's a Class C felony and it just doesn't apply to that type of crime. That's a problem. So you might have to wind up burning a second program, which is the accelerated rehabilitation program. I'll put a link to that program in the description as well. So now you have to use two programs to resolve one charge. Luckily, most of the local prosecutors understand the situation. They're willing to work with us to resolve the risk of injury charge in context with resolving the domestic violence case. But it all depends upon the allegations of your specific case. If you're charged with risk of injury in a domestic violence context, you should immediately contact a domestic violence defense attorney. If you'd like to talk about your case and the specific allegations and how I think we can go about defending it, feel free to call me for a free consultation. I'd be happy to talk about the specifics of your case. Also, if you'd like, post a comment in the video below. I'd like to share your comment. Of course, you don't have to get into specifics about your individual case. I'll give in a response. And I thank you for watching the video today. I hope it was helpful. And again, thank you for watching.